Welcome to another episode of The Velvet Hammer.
And here we go.
Catch him distracted.
No, I'm not
he
distracted.
He normally is distracted.
No, I'm ready to go.
Whatever.
Okay.
All right, this is session number 4 on Voir Dire. We're going to talk about peremptories. And what is a peremptory?
Peremptory is the this is so crazy. Every side gets a number of peremptories to remove a juror from the jury, regardless of the reason. You don't really have to explain the reason unless it is a pretext to remove them because of a protected class.
Also
They're part
known
of a protected
as
class. It's called
Batson.
Batson. And Batson's a criminal case and involves a criminal defendant who was African American who said, they removed all the black jurors from my jury, and I am not being judged by a jury of my peers. And the case went up, and the court said, yeah, you can't do that. And then later on, it was extended to other protected class, which is gender. You cannot remove people because of their gender. But the Washington Supreme Court has expanded it with a rule. Karen, tell us about it.
Well, the Washington Supreme Court, actually, some people on it would actually like to get rid of peremptories altogether because they can be used for these discriminatory purposes. And they're hard to catch that unless you're counting numbers alone. I'm against removing all peremptories. I think peremptories are really good, especially when it's hard to get people off for cause. But I've seen a lot of abuse. And, I mean, I've had types of people that I periodically have not allowed on juries or made a conscious effort to, like, get rid of them. So I want to talk about how this goes. So there's a lot of philosophy of how to do peremptories. The judge will tell you at the beginning how many you get. Normally, it's 3 per side. However, if it's like 1 plaintiff and 5 defendants, that's not going to work. They're not going to get 15, and you're going to get 3. So you have to bring motions, and the judge will negotiate that. Normally, the combination of the defendants will be the same as the combination of the plaintiffs. So if the plaintiffs are going to get 3, the defendants are going to have to share 3. The defendants are going to get 5, defendants are going to have to share 5. Maybe a judge will be nice and give them 1 extra, but normally they should be about the same split. And then there's other types of rules on that, like how do you make a peremptory? Are they in secret? Do you have to say, who's coming up or not? So how do you do it, right? Normally you say, plaintiff will thank and excuse juror number so-and-so, if you're going to do that in person. If you're not going to do it in person, then the jury's excused and you just tell the judge what numbers and you go through.
Most like in criminal court, at least in federal court, the defense gets 10 peremptories by rule.
Oh, there you go.
And the prosecutor gets 6. And so, but civil's not like that. Civil's
completely different.
And the practice in criminal court is that the court does not want you to exercise your peremptories in front of the jury because it's almost like I reject you. And so what you do is after the jury has been voir dired, you write down your peremptories, but you go side by side. So like they have a list.
Yeah.
It goes to, so I get 10, they get 6.
Yeah.
So they go write 6. They put Mike Todd. It comes back to me. I put Karen Koehler. And it goes back and forth. Or we just use the juror numbers, whichever. And then at the end of the whole thing, the judge will say, the following jurors are excused. Now.
Wait, no, before you get to the now, we're still in the peremptory.
Okay, now we're peremptory. Now say I put Karen, okay, as mine, and then I dismiss Karen because she's a woman. Because I don't want a woman. It's a domestic violence case, and I don't want a woman on this who's going to sympathize. And that she's the only woman that's going to be on the jury. Or she said something in her voir dire. She said, I'm a survivor of domestic violence. Okay? And a judge asks her, well, what happened? And she says, I was abused by my husband. And, okay, well, can you still follow the law as I instruct you? Can you be fair and impartial? Karen says, absolutely. I think this is the most important service. And gives the best answer. And I cut her anyways. And they think it's because she's a woman. and because of these views. What would you do?
Then you challenge that.
Okay. Now, how do you challenge that? Tell us process-wise, how do you challenge that?
Well, in civil, all you just say is, I challenge that.
Okay, but okay, so you challenge that. What happens procedurally?
Then the judge is going to ask those questions.
Okay, the judge is going to ask me,
What is the basis?
What's the basis? And I have to give what's called a neutral reason.
Yes.
Right? And I'll say like, oh, judge, it's not because Miss Koehler is a woman. It's not because of this domestic violence. It's that I just got a feeling. You know, I was assessing her credibility. I was asking questions. And, you know, I just don't think that she is the right... That's the whole nature of a peremptory, is not to question my pretext. I just didn't feel like she could follow the law and stuff. And then Karen would respond.
That's not good enough.
That's not good enough.
Yeah.
Because you asked her.
Yeah.
So then at that point, the judge can deny my peremptory.
Now, if you had said something like, well, her husband knows the plaintiff, they are in the same country club and they golf together.
Then he said, Your Honor, this is not about Miss Kohler's gender. This is about something entirely different. They know each other. There's a connection. It's not direct, but, you know, removed. And I'm entitled to the peremptory. Yeah. And then I get my peremptory. Okay? So, but what about some of the tactics behind peremptories?
So here's some of the problems.
Yeah.
You got to be really good at math. You have to count. You have to know.
Why?
You have to know basic counting because you have to know where the ones that you really don't want on. And so you're anticipating in the future, like if I take off this checker piece and this checker piece and this checker piece, then those big bad checker pieces are going to come back and get me later. So you have to make a lot of tactical decisions when you're counting, especially when you get to the for-cause challenges. You're counting madly. And I've seen people blow it, like make a big boo-boo, like, oh no.
Because they weren't paying attention to who was coming up five people fast.
Yes, and correct. So there's a lot of that going on. So if you have a decent enough panel, and then the judge will this is of cause, for cause, we'll do that later, but there can be, other than if it's about Batson challenge issue, if I just don't like the way you're looking at me, which that is a category for me, there is something there that is not good, and I'm a very intuitive person, like I'm looking at that, that's a good reason. But normally there's categories of people. I don't want medical doctors on my jury, and they almost always get off because they're too self-important to be on unless it's a medical negligence case, which they all want to be on so they can tank your case. Other employees of an organization. If I'm suing Boeing, I don't want Boeing employees on there, and they shouldn't be. They should be able to get off for cause. Same with the government.
If you're philosophically in the school of thought that discrimination directed, I know this sounds a little crazy, towards categories of people is real in life, okay, you're a fan of peremptories. Because essentially what this whole process is to protect access to juries. What I mean by that is that like, you know that people of color, women, have historically been prohibited from being involved in the justice process because of who they are. And so peremptories really serve that. Now, the people who, in my experience, I've seen are philosophically disagree with peremptories believe that the whole process is discriminatory because you are discriminating based on something.
Well, you're playing stereotypes at that point.
Yeah.
Well, what I'm doing is, and I think that what makes good voir dire is you have to be extremely fast. This is why we've talked before about how important is it to be fast.
Yeah.
There is nowhere where it's more important than in voir dire. And so what I'm going to do is I'm going to go in with stereotype. It's a shortcut for me. I already know. Young jurors, good on liability, bad on damages. People that come from out of the country do not understand anything about monetary justice.
But right there...
Hold on. Let me finish.
Okay.
I have this set of preconceived prejudices that I'm going to just accept. But I also know, as a person in the world, that I just need one thing from you. So it's like blink. You are prejudiced. I accept that. We are all prejudiced. All of us.
Yes.
So I don't fight it. I allow that prejudice, But that's what you are there to talk to them for, because it's just a prejudice. So I will leave on. I have left on so many people that on paper I should have taken off. I've had jurors that are defense lawyers. I've had jurors that are religious, people that have religious beliefs, strong religious. I've had jurors on from other countries that came to the United States and became citizens. I have broken every single stereotype, but I don't fight it starting off, because I'm just looking for anything I can get, any little piece of information to start off. And I know this category is suspect, but that doesn't mean that I'm going to keep a prejudice.
Well, and I was going to ask, when that happens, are you waiting for different answers as it goes along? Like if there's someone that you want to remove and there's a couple people that might or might not be who you want, are you making choices on that?
Let me show you. When I see a book like this, right, Maya Angelou, I'm thinking, okay, it's poetry. It's going to be fluffy. Okay, right? Her poetry is not fluffy, by the way. I'm going to open the book, glance at it, and see, well, this is actually a book, and it is not fluffy. That's how fast it took me, right? So everybody has a prejudice about everything. This is a book. I thought it was a book of poetry. This is a bowl. It looks like it's plastic. It's ceramic. That's how quickly. But our brains, you're crazy if you think that we don't engage in prejudices and biases. And they're not all negative. That's how we function. We have I came into this room, opened the door, expecting to see it look like this. That was my assumption.
Okay. So that's a really good example that she just did with the book. Don't judge a book by its cover kind of mentality, right? Okay.
I wasn't even that smart to come up with that.
I mean, no, but I mean, this
true.
is just this is wonderful, because if I know you're on a jury questionnaire, and then one of the questions is, what is the current book you're reading? You say, Maya Angelou, All God's Children Need Traveling Shoes. And I go, oh, he is a sensitive type. He loves. I want him on my jury. He's going to be a sweetheart. And this is wonderful. Maya Angelou, the poet. But I get focused on that. I make this association, but I don't know deep down there's an experience that you've had which completely colors your judgment at odds with what I'm trying to pursue in my case.
Let me give you another example.
Example that.
Here's a prejudice that many plaintiff lawyers have.
Yeah.
And it started off, I've been doing this for a long time. They've been injured. They're going to be sympathetic. They've been in a terrible crash. They're going to be sympathetic.
Yeah.
They know what it's like. Au contraire.
Well, I was going to say, I've seen that one go wrong before myself.
Let me tell you, when people have been injured or gone through similar kinds of things, A, they didn't get paid for it. B, they got their medical bills and that's all that they wanted. C, they're living with it and they're doing fine. Sure, it's not great, but you just have to, life is life. You have to do life. They can be very unsympathetic and very judgmental, even though you thought that they were going to be the best ones because they were the most similar. So when I'm saying prejudice and bias, we all have it. And you have to have it in order to function in the world. Your brain has to have those shortcuts that it could, hey, I know that this is a carpeted room and that's a wood room.
Yeah. This is where my own bias has come against me. Mm-hmm. I had a person on one of my juries who was placed on a jury who had experience with law enforcement as a youth, never amounted to a conviction, okay? Meaning they were never disqualified because felons can't be on juries, but had been arrested. And I thought, this person is going to understand that the process is unfair. Mm-hmm. And there is and they were a person of color, and the person I was representing was a person of color. What ended up happening is that juror became the person who was against my case, okay? Because they said their experience afterwards was, you need to take personal responsibility for your life, okay? This is not an easy life, and you need to do more and do better. And it was like the complete opposite. And like, it showed me that like the cover thinking is just as bad. The person who comes in and tries to target to remove a juror because of the color of their skin. Does that make sense?
Oh yeah, totally.
You know.
But what I was going to ask is, so then you're kind of at the mercy of the questions that you're asking during voir dire to hope that you sort of uncover that kind of thing.
You better be good at it.
Yeah, because you, like you said, your stereotype bit you on that one.
Bit me hard early on in my career, and I realized it was just I can't do that.
So if attorneys come in there with their written scripts,
they're not always going to win.
It all.
Yeah.
I mean, and sometimes it's simply watching the juror as they're answering the question and watching their face.
Yeah.
People will tell you. People are transmitting. Now, I remember, again, a long time ago, I read a book that was written by a guy that was for the purpose of telling people how to either get off a jury or undercut the whole system. It was one of those fascist kind of, I don't know if it's a fascism or it was a very anti-government, anti-jury.
Just sort of anarchist style.
Yeah. And I read it because I wanted to know and what they would do and how they would do it. And if you met someone that was that committed, it would be hard to know because they'll say all the right things unless you can pick up on the subliminal.
So you're talking about the people that want to get on the jury to mess it up or something, not the ones who are trying to get off being on a jury.
Both.
Both? Okay.
What I have found is that most people, right? Not all. When they're on those jury panels, they transform from wanting to get off of it immediately to wanting to stay on it at all costs. They will try to articulate. They do not want to get off once they've survived. Do you have a hardship? Even people that have a hardship and want to get off, they won't make it easy for you to get them off. No,
they won't make it.
It's
easy.
Psychological.
It's kind of weird,
thing.
like they reverse after they're not let go for the reason they wanted.
Because I think it's a whole compilation of things. Number one, they don't want to be humiliated by right? A fear of embarrassment, fear of how we look to other people is an instinct. And I've told you this before, like one time I was at the gym, this is many years ago, when I used to run inside, and I'd run fast. I'd run a bit pace between 7 and 7.5 on the treadmill for like an hour and a half. And I wanted to go get a drink at the waterfront, ran off, got off, forgot that the treadmill was still going, got on it, and just went flying. What is the first thing I did? Did I look at the scabs on my knees and my arms? No. I looked up to see who saw that happen to me. That's instinct. That's an instinct that you cannot control. And so part of it, I believe, is the peer pressure of being in there and not wanting to look like you got taken off. So that's a very big part of it psychologically. Second is that I think there's some curiosity. Once you've tried to get off of it and you haven't been successful because like your plan wasn't good enough or your trip wasn't during the time that we're going to be in trial or your employer is paying for you, there's kind of an initial acceptance that's easily satisfied when you start seeing like, well, this could be interesting.
I mean, I think that, like, for me, it's that you have to be authentic with the jurors. Like, you have to be authentic with them. And you're not going to be able to solve. This is why, in my opinion, I think, like, really voir dire is a crapshoot. It's hard because you have people start one place, end up in a completely different place because of the process. And what you can do is if you tell people, this is important, this is very significant, and you empower them and say, what you do is going to really impact people. I think people want to step up and they want to be part of that and they want to do the right thing.
It is a mob mentality though, because the longer they're in there, they're watching people. And so the people stop becoming strangers to, oh, that's the guy with the glasses and the backpack. And that's the person that, they all start to kind of connect and form a group. So there's a group process, and then there's that embarrassment process, and they don't want to get off.
And I can say from my own experience that curiosity, it kicks in hard once you're in voir dire.
Yeah.
Like, you know, it's like being on the TV shows at that point. You know, you start feeling like what you've seen, and you're experiencing the real thing too. So, I mean, that happened to me. I mean, I wasn't trying to get off or anything. I was just going through voir dire, but I did start thinking, God, it'd be cool if I got on the jury, you know, and I'm answering the questions, and then there's, you know, it kind of looked like I wasn't going to be on it.
Yeah.
And then everything started moving real fast. All of a sudden, I was on it. We weren't sure which one's going to be picked. Was it going to be an alternate? Next thing I knew, I was on the jury, and they were, you know, doing opening remarks.
You know, you always hear, well, people are super scared of public speaking. It's like one of the number one fears. But for some reason, during the jury selection process, even though you are in public and sometimes with a lot of people, most people are not. Their fear is tempered because everyone.
Yeah, no,
is
it's a
similar.
group. You're not singled out.
Yes,
Yeah.
and so you don't see people that have extreme fright in speaking. People just kind of start doing it, and there's a comfort in the fact that what's happening now. That said, they will resent the lawyer that is bully or badgering them, or trying to make them feel negative or shame.
Yeah.
So just remember, like, you're not talking to one at a time in an isolated room. So peremptories, though, when you get to the point where you got to get them off, you should have some kind of a grid. You should be able to count to see who's coming up, and you better know how many, you know, strikes for cause that you can get if you haven't already gotten them off. Well, you should have tried to get them off, but we're going to talk about cause challenges separately.
Okay. Part 4 done.
Okay. Well, that's all for today.
Until next time.